everyone, this is Gabby. I wanted to wish y'all a happy Teacher Appreciation Day, happy Mother's Day, and happy Cinco de Mayo. So with all the holidays coming into play, especially Mother's Day, birthdays, summer vacations, I want to talk a little bit more about visitations. So something interesting for y'all to know, say for example, you have the standard visitation order. What that means is usually it's the first, third, fifth weekend of the month and Thursdays during the school year. So say for instance, you're a mom and you don't have your little ones this weekend. Pursuant to your order, it would allow you to see your little ones. It's always important to follow the rules of the order. Now I understand these orders come in book-sized pages and it's hard to decipher. What we can do at this office is schedule a consultation, work with you, go through the order and help explain what your rights are as a parent. Another interesting tidbit is that these orders also allow for the non-custodial parent, meaning the parent who doesn't have the child on the custody of their birthday, to see the child on their birthday. I think a lot of parents are not taking advantage of these little rights awarded to you by the order. So I understand it can be confusing and it can be very, very overwhelming, but we're here to help you and happy to explain any questions that you may have when it comes to visitation and asserting your rights. So a lot of questions that we're getting in the office are regarding grandparents' rights. And so while a grandparent does have rights, in limited circumstances, oftentimes a grandparent will only be allowed to file suit if they have parents' agreement, meaning mom or dad are allowing you to join the suit. A parent is away, such as they're deployed or incarcerated, or in the unfortunate event that CPS is involved, a grandparent can intervene in that and ask to have custody. And I understand there's a lot of different dynamics with that, which is why our office is very happy to talk to you, go through these issues and see what remedies or ways that we can help you assert your rights. So a lot of questions that come across our desk are regarding modifications of child support and visitation. A lot of people think they're one and the same. Actually, we can ask to modify one, if not both, if we meet the certain criteria. So something that happens a lot, what the court takes into effect, is whether a material or substantial change has happened either to one of the parties involved. That could be the parent, the guardian, or the child. When we're looking at that, the court means is, did someone get remarried? Did someone have another child? Did someone get injured, disabled, that would affect their obligations to support? Now, I don't want to scare you into thinking, well, I just got remarried. Are they going to look into my wife's income or my husband's income to pay child support? Absolutely not. The court does not look into that. What they would look into, and something that would be beneficial in your situation, is say you have a child from a previous relationship, you get remarried, and you have subsequent children from that. When it comes to modifications for child support, the court will look into how many children are you obligated to support. That could be children from previous relationships, children from current relationships, including children that you plan on adopting. So marriage is a big issue for a lot of people. You know, you finally meet the right person, you get along well, and now you're combining families. How does that work? Well, our office can kind of help explain it, and with this newsletter, simply, those children of your spouse are not considered in your child support unless you choose to adopt them and you go through the court's process. So as much as your ex wants to threaten you saying, I'm going to take your new husband's or wife's income into account, that's not going to happen. However, like we mentioned previously, if you have subsequent children with your new spouse, that can be taken into consideration as far as how they modify what you're obligated to pay monthly. Something that also takes into account is, let's say at this point your ex-partner wants to allow your little one to start living with you, but you're still obligated to pay child support. You can modify based on that. There's a lot of different factors as to how the court can look into modifying child support and visitation with respect to your obligations as a parent. We talk about child support orders, we talk about visitation orders. What does it mean? Well, aside from us helping you parse that up and understand what's going on, something that we want to stress to you is that each parent, each party to that order is obligated to comply. So let's say, for example, your ex is not letting you see your little one because you're defaulting on your child support payment. Well, guess what? The law says that you're still entitled to visit your child. And anytime they deny you those visits, pursuant to you seeing them according to that order, you could hold them in contempt. Our office focuses on sending demand letters, trying to work with parents before seeking legal action. On the flip side, as much as a parent wants to hold their children away from them, let the court handle that. They're responsible for ensuring that the other parent is supporting their child and meeting that obligation. That said, if both of you want to take it into your own hands, it's very important to understand that any informal agreements or arrangements will not be honored by the court. And if the court were to find you in violation or hold you in contempt, as they say, the party found to be in violation of that order would be facing up to 6 months in jail, a $500 fine, and could be ordered to pay court fees and attorney's fees for the other party. So rather than trying to navigate it yourself and get yourself in a sticky situation, we advise you to just call us. We're happy to work with you. We can look through that order and remind you what your rights are. A lot of our newsletter has been focused on orders. Now, what happens if there is no order? How do you come to an agreement? Generally, most parents want to work together and they allow the other parent to see their child when they can. Here's the problem with that. Because both parents by law are entitled to their child, if one parent decides to leave, they're not stopped. If one parent decides to say, hey, I'm going to go live in Juarez for a while, I'm going to go travel the world with their little one, there's nothing precluding that parent from stopping you. Likewise, if you have an order that doesn't bar any geographic restrictions, you want to make sure that you're covered. So when you have these orders, let's say, for example, you have your little one, your ex comes and goes, they see the little one as they please, and now they're wanting to see their baby. Now they're wanting to pick them up and spend that quality time. You're right, you don't have to hand them over. They can always threaten to call the cops. They can always threaten to have someone else intervene, but without an order saying that parent is entitled to child these certain times during the week, months, or a year, the cops can't do anything. They're not going to arrest you. You cannot kidnap your own child. So it's always important to get that cleared up and get that taken care of with the courts. Now, let's say, for example, you had an informal agreement and you and your ex, you and your partner moved to another state. You decide to come back, or they leave without you with the little one. What do you do next? That's a tricky situation, right? Since you don't have an order, a lot of times the court will look at jurisdiction, meaning where is this child a resident of, right? Are they a resident of El Paso because they were born here and they spent the first few months of their life here? Or are they a resident of another state? And so a lot of that varies from situation to situation. So let's say you and your little one and your ex lived here, for the first 5 years of your little one's life. Your ex moves to Colorado, and suddenly you get an order for child support. You're on the hook for that. You're obligated to pay for that. You're making the arrangements. But what about enforcement? How do you ensure that they're enforcing that? Oftentimes, these notices, these orders are enforced by the Attorney General when it comes to visitation, absent any underlying agreement. So in order for Colorado, California, any other state in the US to enforce it, they would need to register it here in Texas as well. But generally, most of the time, they'll do it by direct deposit. They'll find other ways to collect that money from you. Now, let's say you're in that situation where, hey, I want to modify it. I'm wanting to have my child brought back here to Texas. That would be something that, we would want to consult with you and take a look at these orders to get a better understanding of how we can help you. Not all hope is lost, but it is a little bit more difficult knowing that there were no pre-existing orders and we're looking at orders from another state. But that doesn't mean that it's not doable or that you can't enforce your rights. So let's talk about termination of child support. How and when can that happen? So let's say you haven't heard from your ex. At this point, you want nothing to do with them. One way you can do that is try to reach out and try to get an agreement. A court will listen to that in most situations. But let's say there's no agreement, can't reach them, can't hear them. Generally, termination of child support will occur when the child reaches 18, they join the armed forces, they get married, or any other term stipulated in the order for support. Now, I know we touched a little bit about remarriage, a little bit as far as will my ex be, or will my new spouse be responsible? Now, in these type of situations, let's say your new spouse is also named a conservator for this child. During the marriage, you and your spouse are responsible for that child. of your prior relationship, but let's say you and spouse number 2 end up getting divorced. That would also result in a termination of that spouse's obligation to pay child support if they were named conservator. Another issue the court looks into consideration is if the parent who is named the biological father of the child is not the father. Say, for example, he signs the birth certificate, paternity testing is done, and he is not the conclusive father like they do in Maury, then guess what? They're not responsible for that child. Baby daddies, let's talk about them. How are they identified? How are they responsible? And how does the court take that into consideration? Well, there are many ways that one can be identified as a father. For example, a man can register with the state of Texas, assuming that paternity, saying, I am responsible for this child. Most cases, they're with their partner and they sign off on the birth certificate, or a child born in marriage. These are the traditional ways in which the courts have recognized paternal rights or the obligation to assume the role of support. Now, we talk a lot about obligation and termination of child support. Without an agreement, generally child support will be automatically terminated upon one of the following. Child turns 18, child remarries, say at this point, genetic testing is done on the child, and it turns out that the person who assumed the role as father is not the biological father. There are some caveats to that, but generally that is when the court will look at that. Or say when a party remarries, and although the new spouse is not the biological parent of the child, but they are named a conservator in the order, upon termination of that subsequent marriage, child support obligations cease to exist.